Wednesday, April 22, 2026, AGNDD Intelli Report topic. A $440,000 breast reduction, how doctors cashed in on a consumer protection law. Please pardon any visual and informational inaccuracies in this partially AI-generated article-based video. A $440,000 breast reduction, how doctors cashed in on a consumer protection law. A law meant to end surprise medical billing accidentally created a multi-billion-dollar industry that is making doctors richer. April 22, 2026, by Sarah Cliff and Margot Sanger-Katz, The New York Times. The reporters analyzed data on more than 3 million arbitration disputes and reviewed dozens of lawsuits. Dr. Norman Rowe, a plastic surgeon with offices in New York and Florida, advertises on his website that breast reduction surgery usually costs between $15,000 and $25,000. But these days, his practice sometimes earns $440,000 for the procedure. Dr. Rowe has taken full advantage of a new arbitration system, part of a major consumer protection law Congress passed in 2020 with bipartisan majorities. The No Surprises Act was designed to eliminate surprise medical bills for patients who showed up in the emergency room and were treated by a doctor who didn't take their insurance. It bars those out-of-network doctors from billing patients directly. Instead, they can plead their case to a government-approved arbitrator. If they win, the patient's insurer has to pay their desired amount. By all accounts, the law is successfully protecting patients against bills from doctors they never chose, but it has also generated an expensive, unanticipated consequence. Doctors have flooded the arbitration system with millions of claims. Most are winning, often collecting fees hundreds of times higher than what they could negotiate with insurers directly or what they could have earned from patients before the law passed. I'm still glad we passed the bill because we got consumers out of it, but we need to rein in this arbitration process, said Representative Frank Pallone, Jr., Democrat of New Jersey, who helped negotiate the law. Some health plans said they have increased premiums this year to cover the extra costs. The United Service Workers Health Plan, which covers 20,000 trades workers in the New York area, said it boosted premiums by an extra 1.75 percentage points to offset arbitration awards and fees. The system has also enriched a new class of specialized businesses which assist doctors in navigating the bureaucratic process. This is a recipe for driving up healthcare costs, said Karen Ignagni, the executive chair of Emblem Health, which sued Dr. Rowe in March, arguing his use of arbitration amounted to fraud. There are no checks, there are no balances, there's no oversight. When the law passed, government officials estimated that about 17,000 cases would go to arbitration a year. Instead, doctors brought 1.2 million such cases in the first half of last year, and won around 88% of them. The arbitrators are doing well too. The fees they earn for deciding cases, which range from $425 to $1,150 per case, have added up. They earned $885 million from 2022 to 2024. The number of disputes in arbitration has exploded. Cases per quarter. A small share of cases, less than 1%, are categorized as split decisions. They are not pictured. Source: Centers for Medicare and Medicaid Services, by the New York Times. In arbitration, doctors and insurers each propose a price for the care, along with arguments for why it is appropriate. An arbitrator must pick one of the two numbers, and there is no opportunity to appeal the decision. Arbitrators have repeatedly approved doctors' submissions of extremely high prices for common medical procedures, according to court filings and a New York Times analysis of a large public data set with basic information on each dispute. A neurosurgery practice outside of Philadelphia went to arbitration after the health plan. Highmark offered its standard payment of $2,660 for a diagnostic procedure to measure blood flow to the brain. An arbitrator awarded it $333,000 instead. A New Jersey anesthesiologist was awarded $14,560 in 2025 for an X-ray guided steroid injection. Many claims that shouldn't be eligible for arbitration, such as those for patients covered through the government programs Medicare and Medicaid, move through the system anyway. The claim from the New Jersey anesthesiologist involved a patient on a United Healthcare Medicare Advantage plan, according to a lawsuit that United Health has filed protesting the arbitration decision. The doctor's billing company recognized the submission was a mistake and tried to withdraw it before the decision, but his lawyer, Eric Katz, said that the arbitrator clearly thought the award was appropriate. "No one put a gun to anyone's head," he said. "If the plans have issues with the way this is being handled, take it up with Congress." Medical specialties like spinal and plastic surgery, for which surprise bills were rare before the law, now frequently have cases in arbitration, according to the public data. Some practices are using the law to obtain high payments for routine medical care, including gynecologists who have won fees 600 times higher than usual rates for placing intrauterine contraceptive devices, or IUDs. A Rowe plastic surgery location in Red Bank, New Jersey. Credit Andres Kudaki for the New York Times. The money does not always end up with the doctors, but instead can go to the owners of their practices. The Times interviewed two physicians who show up repeatedly in public data files. Both said they were salaried workers and uninvolved in the claims filed under their names. The government has hired 15 firms, some boutique vendors and others large contractors, to arbitrate billing disputes. Doctors and insurers can select a firm if they agree, or be randomly assigned one if they do not. Health policy experts have been surprised to see such lopsided results that favor doctors. Some argue that because the arbitrators are paid per case, they may have an incentive to render decisions that keep doctors coming back. Arbitrators may also, like the broader public, prefer doctors to insurers, said Matthew Fiedler, a senior fellow at the Brookings Institution who has studied the law. Arbitrators are people, and the typical person likes physicians. David Farber, a lawyer for the newly formed Coalition of Independent Dispute Resolution Entities, a trade group representing some of the arbitration firms, disputed the notion that arbitrators acted improperly. "We're getting the job done," he said, "and the job is getting done consistent with how Congress set the process up to work." Doctors contend that they only pursue arbitration when insurers offer unreasonably low payments. "We have very strong preference to be a network at sustainable rates," said Dr. Richard Heller, a senior vice president at Radiology Partners, which employs over 4,000 radiologists. The company now has 150 staff members working to bring arbitration claims. Eyebrow-raisingly high, Dr. Rowe has practiced for decades on New York City's Park Avenue and in New Jersey. Last winter, he opened an office in Palm Beach, a few miles from President Trump's Mar-a-Lago resort. Just before the inauguration, he told the New York Post the office had been overrun with clients who wanted to look good when they have FaceTime with the leader of the free world. Dr. Rowe did not respond to multiple requests for comment from the Times. On social media, he flaunts a lavish lifestyle. An Instagram post in February detailing his 60th birthday party featured a performance from the rapper 50 Cent and a custom cake recreation of his 1950s vintage Porsche. A video posted on Dr. Rowe's Instagram showed Dr. Rowe celebrating his 60th birthday with appearances by celebrities 50 Cent and Robin Thicke. Health insurers do not cover many of the elective procedures that Dr. Rowe provides, such as penis enlargement. That service became a big enough part of his practice that he has trademarked the nicknames Dr. Penis and Dr. Penis. Breast reductions, however, are different. They are often treated as medically necessary because they can reduce back and neck pain. Before the No Surprises Act, Dr. Rowe's practice was out of network with Emblem Health, but he accepted fees $30,000 or lower for hundreds of breast reduction surgeries, the lawsuit claims. In 2024, the lawsuit says, he started routinely performing surgeries on Emblem Health patients in hospitals that accepted the insurer's in-network payments, though he still did not. Under the No Surprises Act, Doctors in such situations can provide patients with a waiver that warns of additional costs. If patients sign that form, the doctor has permission to bill them directly. Dr. Rowe does not hand out that waiver. That allows him to take his payment disputes to arbitration. He and his practice have filed more than 6,000 arbitration claims, according to an analysis of public filings from the Georgetown University Center on Health Insurance Reforms. He has won more than 85% of his cases. Dr. Rowe's winning track record. Cases per quarter. The totals combine numerous variations on the names of Dr. Rowe's practices, Rowe Plastic Surgery and East Coast Plastic Surgery, in the public filing system. Source: Georgetown Center on Health Insurance Reforms, by the New York Times. The lawsuit offers details about 5 of those cases, all for elective breast reduction surgeries. In the first case, in November 2024, Dr. Rowe won a payment of $112,500 that covered his work and the work of an assistant surgeon. In the fifth one, in late December 2025, his practice brought and won separate claims for each surgeon, totaling $440,000. Altogether, the practice won more than $1.4 million from those 5 surgeries alone. Emblem Health's strategy also changed over time. According to the suit, the company started with a low counteroffer, around $6,000. Over time, it tried offering fees as high as $124,000, but continued to lose. The plan's lawyers also started including language in their briefs, stating that Dr. Rowe has a pattern of exploiting the process. Dr. Rowe's briefs to the arbitrator are not public, so it is unclear exactly what arguments he made to justify the much higher rates he was claiming in arbitration. The law directs arbitrators to consider several factors, including the usual price insurers pay, the doctor's experience, and the patient's complexity. Elevance Health, another insurer, said that breast reduction surgeries are now its most expensive category of arbitration claims. Ariel Baywitz, the company's vice president of health economics, said one Connecticut plastic surgery practice has escalated its earnings from the procedure, beginning at $70,000 in 2024 and hitting $440,000 late last year. Michael Gottlieb, the lawyer who handles Dr. Rowe's arbitration filings, declined to speak about continuing litigation, but did broadly defend his clients seeking much higher amounts than insurers typically pay. He described the arbitrators as having reverse sticker shock at how low the health plan payments were. When they got wind of 3-digit payments for massive, complex surgeries, and they know they pay their plumber more to fix a toilet, they just gravitate toward the provider's offers, even if they do seem eyebrow-raisingly high, he said. Arbitration decisions are supposed to be binding, but Mr. Gottlieb said that health plans often refuse to send payment. He has sued multiple insurers over the issue. In March, one doctor he represents received a letter from the Motion Picture Industry Health Plan, which provides coverage to many film workers. The letter, which the Times reviewed, stated that the plan would not pay the amount an arbitrator selected because it does not constitute appropriate use of plan assets. Silence in Congress. Surprise billing was an urgent topic in Congress. But these days in Washington, the law's unexpected results are rarely discussed. Credit: Eric Lee for the New York Times. For years before the No Surprises Act passed, surprise billing was an urgent topic in Congress. Lawmakers from both parties denounced the high bills that ambushed patients. But these days in Washington, the law's unexpected results are rarely discussed. Instead, many legislators who worked on the law emphasized the success of consumer protections. "My focus is on ensuring everyone can get the care they need without worrying about the cost," said Patty Murray, Democrat of Washington, who helped craft the bill. Senator Bill Cassidy, Republican of Louisiana and a physician who helped write the law, said the large awards were a sign that insurers were not making reasonable offers. If they're winning, it's because the insurance companies are not coming back with a reasonable thing, he said. In late 2023, the Biden administration proposed changes to the arbitration system, including more scrutiny of ineligible claims. The Trump administration has not yet put into place those reforms. Only one bill has been introduced in Congress to change arbitration, and it would increase penalties on insurers that fail to pay doctors quickly after cases are concluded. Seeing little movement in Washington, health plans have turned to the courts. They have filed at least 20 lawsuits against doctors and the companies they use to submit claims. But this month, judges in California and Florida dismissed 2 such cases, finding that Congress did not intend for judges to review the arbitration awards. If an insurer believes doctors are acting improperly, the Florida judge wrote, it should raise the issue in arbitration. Katie Edmondson contributed reporting. Sarah Cliff is an investigative healthcare reporter for The Times. Margot Sanger-Katz is a reporter covering healthcare policy and public health for the Upshot section of The Times. Comments? KFD, Washington, D.C., 3 hours ago. I'm curious how many of the practices that are exploiting the NSA arbitration rules are owned by private equity companies. There is some suggestion that corporate decisions drive NSA arbitration requests, in at least some cases. But the authors don't say whether these are PE-controlled practices or not. Sarah Cliff, investigative healthcare reporter, 3 hours ago, at KFD. This may be an issue we dig into later, but in the meantime, you might be interested in this report that a think tank put out on this topic last year, https://pestakeholder.org/news/profit-on-all-sides-private-equity-and-no-surprises-act/. Aggrieved taxpayer, New York State, 4 hours ago. What this really shows is the anomaly of having this procedure, breast reduction, covered by insurance. Thus, the arbitration system comes into play. Most plastic surgery is elective, and the fees, admittedly quite high, are paid in cash. Dr. Rowe has really figured out a way to game the system. What a niche. Separately, what is fascinating is that baseball arbitration is used. I wonder who lobbied for that. Sarah Cliff, investigative healthcare reporter. 4 hours ago. At Aggrieved Taxpayer, I can at least give you the answer to your last question. During negotiations around this law, it was generally the lobbying groups that backed doctors who were supportive of baseball-style arbitration as the way to resolve billing disputes. Insurance plans largely supported setting specific rates to solve this problem, but that policy proposal did not win out. Harry, Maryland, 4 hours ago. An arbitration system based on each side proposes a number. The arbitrator chooses one, is intended to force each side to the middle, to pressure them to propose reasonable numbers, for fear that an unreasonable number would result in the arbitrator choosing the other side. If the 2 sides are proposing wildly different numbers, then the system is broken, and it's the fault of the arbitrators. They should be estimating the value of the service and choosing the side that proposed the price numerically closest to that reasonable value. How does an arbitrator ever choose a number like $440,000? Even if the insurance company proposed a $0 payment, that should be the winning proposal as long as the arbitrator's estimated value is below $220,000. Any other result draws into question the competence or impartiality of the arbitrator. Sarah Cliff, investigative healthcare reporter, 4 hours ago, at Harry. This is a great question we weren't able to dig into in this story. It's an outcome that has surprised many of the legislators who wrote this law. They modeled it after the arbitration system that Major League Baseball uses to settle salary disputes between players and teams. In that scenario, the offers from each side are much closer together. It's a puzzle we're hoping to report more on. Why did arbitration produce such different results in this scenario? Doug, Kansas City, 4 hours ago. Another tragedy in terms of fair compensation to physicians where the cost is borne by consumers. A straightforward solution is to do what every other market has to do, and that is to require physicians and medical practices to publicly post their prices for common services, clearly listing both the negotiated insurance rate and a cash pay rate. This dual disclosure would create real price visibility for patients, employers, and insurers alike. People could choose to not buy insurance and pay with the cash option. I recently did this in lieu of waiting 2 weeks for my insurer to approve an MRI and found the cash option to be extremely reasonable, especially for getting the service the next day versus what I pay for insurance premium. The benefits are immediate. First, it enables true price discovery in a market that has long operated in the dark, allowing patients to compare costs and make informed decisions. Second, it establishes a consistent rules of the game framework, where all providers compete under the same expectations of transparency rather than relying on opaque billing practices or arbitration leverage. Finally, it would help moderate excessive pricing by introducing competitive pressure, reducing the need for costly disputes between insurers and providers. Sarah Cliff, investigative healthcare reporter. 4 hours ago, at Doug. There has actually been some real progress in price transparency over the last few years. Hospitals are now required to post their negotiated prices with health plans online. I wrote a story a few years ago about the large differences in prices those were showing. https://www.nytimes.com/interactive/2021/08/upshot/hospital-prices.html. It's unclear, however, whether that is actually driving down costs. One worry is that it might increase costs. If one hospital sees another is making a lot more than they are, they might seek higher reimbursements from the health insurer. My co-author Margot wrote a story about the research in this space suggesting this as a possible outcome. https://www.nytimes.com/2019/06/24/upshot/transparency-medical-prices-good-backfire.html. SD. NYC, 4 hours ago. It's no surprise that legislators are passing poorly framed laws with unintended consequences. Seems to be happening more and more often. It's likely that staffers warned legislators about potential problems. Sarah Cliff, investigative healthcare reporter, 4 hours ago. At SD, Margot and I both covered the passage of this law extensively, and, during that reporting, we saw legislators take a lot of feedback on crafting the structure of ending surprise bills. There were many academics involved in the process who provided feedback, and also intense lobbying from dark money groups that also shaped the law. This law was one of the few I've covered in my 15 years as a healthcare reporter that was truly bipartisan too. But even when there is lots of thinking that goes into drafting a law, one thing this story showed me is how unpredictable the outcome could be. Russell, NYC, 4 hours ago. I respond to these arbitration initiations on behalf of small businesses' health plans. We always originally pay 250% of Medicare. Physicians are right to complain that Medicare underpays, it does, but 250% of Medicare is a generous amount. For an ER visit with a scan or LA work done, this might come to about $6K. The NSA is awarding $20K frequently for these events. When we tell small businesses about losing these awards, which are only sometimes reinsured, they freak out and think we are incompetent. The system is broken. Lawmakers don't even care about fixing it. They should really just say that out-of-network fees are paid at Medicare rates or something well-defined. Sarah Cliff, investigative healthcare reporter, 4 hours ago, at Russell. Thanks for sharing your experience in this space. What you're describing sounds pretty common in the dispute resolution landscape right now. Charlie, New Jersey, 5 hours ago. We routinely blame the insurance industry for the high per capita cost of healthcare in this country, yet here we have a really stupid law. How does arbitration award $440,000 for a procedure that normally costs $15-20K? Here's a fix. Legislate that any doctor who doesn't accept insurance in an emergency room has to accept what Medicare or Medicaid would pay for the services. Too many of these docs are deliberately slipping through a hole in the medical reimbursement system to enrich themselves. Years ago, my wife severely damaged her foot late at night, and conveniently a podiatrist was in the local hospital late at night. He didn't take insurance but assured us surgery was indicated and he'd work out the insurance matter. We chose waiting for a second opinion. An orthopedic foot specialist subsequently advised against surgery and favored fitting a boot for 6 weeks to enable the healing. I wonder what arbitration award the podiatrist would have gotten for the unnecessary surgery. Margot Sanger-Katz, health policy reporter, 3 hours ago. At Charlie, when Congress was originally writing the law, lawmakers planned to set up a system similar to the one you describe. Doctors who were out-of-network in surprise billing situations would be paid the median rate insurers pay their in-network providers in the area, but doctors and private equity funds that owned large physician practices lobbied heavily against this proposal. The original bill did not pass. A year later, Congress passed the No Surprises Act with the arbitration system instead. Here's one story about the lobbying effort. https://www.nytimes.com/2019/upshot/billing-laws-add-spending-doctor-patient-unity.html MVM NYC 1 hour ago at Charlie. You cannot possibly maintain a medical practice based on Medicare/Medicaid payments. Hospitals and doctors systematically lose money on Medicare/Medicaid patients. Bird. Everywhere. 1 hour ago, at Charlie, there's fraud in those ERs. My elderly father died a few hours after going to the ER in respiratory failure. A few weeks later, we get bills and EOB statements from all the specialists that supposedly saw or treated him. One jumped out. It was a cardiologist we know didn't see our father that day. We'd been at his side the entire time. That was Mom's cardiologist of 10+ years. She'd have recognized him instantly. I suspect that when someone comes to the ER and dies shortly after, it's automatic for the hospital system to initiate billing for any possible specialty, whether or not anything was done. The patient won't question it. The specialists will be unknown to the institutions paying the bills. No one will know. But Mom noticed. It infuriated her that her doctor could bill $1,600 and didn't step into the room or talk to her. Maybe he looked at a chart or took a phone call in those few hours, but $1,600 in 2008 was awfully steep. My father had his own cardiologist. He'd been to see him earlier in the week, but my father's cardiologist wasn't on staff at the hospital and didn't bill for the day he died. She questioned this at her next appointment, arriving with that bill in her hands. Doctors do not like questions. Mac, New England, 6 hours ago. Odd that the arbitrator must accept either the insurance company's amount or the doctor's. Would make more sense if they could arrive at a reasonable amount somewhere in the middle based on averages or something similar. Margot Sanger-Katz, health policy reporter, 4 hours ago at MAC. This system, sometimes called baseball-style arbitration because it's how MLB resolves salary disputes, was designed to encourage reasonable bids and reduce the cost of using the system. The law does require the arbitrator to consider a benchmark price, the median amount that an insurer pays in-network providers in the market. In every case, the arbitrator sees that number, which is supposed to function as a kind of average. But for whatever reason, that number seems not to be driving many decisions. Java Man, North Carolina, 6 hours ago. The article highlights one physician in particular for outrageous fees awarded in arbitration, but there's a much larger issue hidden in the story. It is significant that many physicians are no longer professionals in private practice, and their numbers are shrinking. The example here of physicians' names being used in a case where they are only employees rather than independent professionals is a growing feature of the health professions today. Private equity is investing heavily in acquiring private physician practices and other healthcare organizations. While still relatively small, their pace of growth is logarithmic. It would be interesting to know the nature of the owners of the two physician employees who show up repeatedly in the public arbitration files. That case smells of private equity where profit is the most important factor by far. Profit is the most significant feature of our healthcare system rather than universal access to care. Minnesota John, St. Paul, Minnesota, 6 hours ago. I would avoid Dr. Rowe like the plague. A doctor who has no qualms about scamming the system in this fashion probably doesn't give a whit about the well-being of his patients. Gretchen Fubar, WI, 7 hours ago. Wait. So the No Surprises Act was written to protect the doctor, not the patient? If Senna Kennedy says it was a good bill to ensure insurers offer the correct amount of money in the first place, then this is exactly what it does. Protects the doctor. Especially with that second bill that increases penalties on insurers for not paying their due amount promptly. And people wonder why U.S. healthcare costs so much compared to other countries. This is the reason. I am limited to what I can sue a physician for in malpractice, and Congress writes these bills. Unreal. Power, CT, 7 hours ago. Not surprising that a supposed fix in a broken system results in costly, unanticipated consequences. Systems are by definition a complex set of interdependencies. It is disheartening to see those who take advantage of everyone to line their pockets. Brandon Pertell, Writing, Massachusetts, 7 hours ago. The perfect metaphor for our entire medical industrial complex. Billing is inexplicable. Any loophole is exploited by those who are already making money, and the rest of us spend our lives either falling through the holes in the net or hopelessly tangled in it. BBB 6 hours ago. Another day, another grift. We have become a society of mercenaries with zero concern for the common good. It's revolting. Another doc. Syracuse, New York. 6 hours ago. If the government thinks that this system is protecting the patient or protecting the consumer, they're wrong. It may protect the specific patient in a specific case, but on the whole, this is going to result in massive increases in insurance premiums as the carriers have to cover these ridiculous arbitration verdicts and will simply pass on the costs. And Dr. Rowe should be ashamed of himself.
Thank you for watching this AGNDD Until I Report, dear viewers. Please like, subscribe, and click the bell button to get notified during new uploads. And make sure to tune in next time. Stay safe and healthy. Cheers.